So on behalf of ACJ and IJR, I would like to just say a few words about Justice S. Murlidhar, whose journey is marked by an unwavering dedication to justice. Following a distinguished career as a lawyer in Chennai and Delhi, he was appointed as a judge of the Delhi High Court in 2006. Justice Murlidhar later became Chief Justice of the High Court of Odisha in 2021, where he spearheaded transformative reforms in both administrative and judicial realms, including the establishment of advanced digitization centers and the Center for Judicial Archives and the Museum of Justice in Cuttack, and, if I might add, starting a novel initiative of establishing regional judicial academies, which is going to go a long way in improving the training of judges. A year after his retirement in 2023, he was designated as a senior advocate by the Supreme Court of India, marking his return to practice. Welcome, Justice Murlidhar. Professor Murali Karnam is also, I should start by saying, an advisor to the India Justice Report Collective. He's a professor of human rights and the director of the Access to Justice program. With a PhD in political science from the University of Hyderabad, his research delves into the colonial history of India's penal system. He spent a decade advocating for prison reforms and prisoners' rights before joining academia in 2013 at Tata Institute of Social Sciences, Mumbai, and later NALSAR, University of Law, Hyderabad. His work spans political theory and penal law, focusing on preventive detentions and prison reforms. At NALSAR, he runs a prison legal aid clinic, engaging students in providing legal aid to prisoners. As the director of the Access to Justice program, he leads a team of advocates, social workers, and researchers to ensure effective legal aid for prisoners. Thank you, Professor Karnam, for joining us, and over to you.
I'll be doing just two things. One, I am very conscious about the nature of the institution. This is a College of Journalism. Therefore, keeping that in mind, and I would be saying a few things. And also some reflections about what we have been discussing since morning. One fundamental conception that I want to place before you is victims of social order are completely different from victims of the state. Let us make this fundamental difference because the nature of the society is different from nature of the state we have, because state is based on a constitutional vision. Prisoners are victims of state, but victims of crime are victims of social order. Any ordinary offender is unorganized, simple-minded. Maybe there are some few organized minds also. They are not backed by public funding, they are not backed by state, they are not backed by law. But prison or criminal justice system has our consent, our public money, our constitutional backing. Therefore, victims of state must be seen completely different from victims of an ordinary criminal. It could be a rape victim, it could be a who lost their property. So this conceptual difference must be kept in mind, otherwise we would be always feeling confused. One end of the spectrum to another end of the spectrum we keep on. Today we can talk about rights of the prisoners. The moment there is a meeting on violence against women, all of us get converted into demanding every prisoner should be hanged. This confusion needs to be clarified first. I must say, in a college of journalism, that journalists have a huge role in shaping a public opinion about how to handle crimes and what kind of prisons we should have, not necessarily from the perspective of constitution. For every report by people like Sukanya, there are lakhs of reports by the ordinary journalists taking information from the police and the courts, a narrative that builds a public opinion where prisoners deserve no rights at all. Deservingly, Sukanya Santa was honored here because it is very rare and exceptional. Otherwise, we are all part of recycling such kind of public opinion, which is a basis for a policy making. So media is continuously creates that kind of conditions which is used by the state to create a draconian laws. This also we must, I mean, you know that most of the journalists are not paid very well, therefore crime reporting sells. This was something that was realized in the early decades of 20th century. Otherwise, every second report, why it is only about crime. So therefore, we have a role, we have a responsibility in understanding why we have the prisons, the kind of prisons that we have. Data is a potent weapon of persuasion, which is being very effectively used by the state. Statistics, static, reality. You know the earlier avatar of statistics? Political arithmetic. Reality is very complex, reduce it to your data so that you can manage the reality. What Maya is trying to do is use that data, empower the citizens like us to turn the table against the state and asking the state, you say these are the standards, please adhere to that. Using the state's weapon against state itself to make it function according to principles of constitution. That is the significance of access to justice report or India Justice Report, in my view. Other than this, we have to just confine to just one or two points that do we really believe prisoners deserve rights? Do we really believe that institutions of prisons must be democratic? This question we have to answer ourselves because in our obsession to security, we want to isolate, separate all the accused, not necessarily convicted offenders. Consequently, we also permanently isolate and separate penal institutions from the entire society, physically as well as conceptually. The question of reintegration, reformation, rehabilitation doesn't arise at all, as long as we think every stranger is a source of anxiety in the age of globalization. So therefore, what is happening is penal institutions are separated, isolated from institutions of constitutional governance. No education institution, no medical and health institution, no other adult education institution do believe that they have a responsibility in making prisons democratic. So if we want to reintegrate prisoners into society, first we need to reintegrate prisons into mainstream governance. We are not doing that. We want to isolate perpetually. Reintegrating prisons into mainstream constitutional governance is the condition precedent for reintegration, rehabilitation of the prisoners. Without happening that, this is the first one is not going to happen. So basically we need to understand what is our moral imagination, what is our essential constitutional framework within which we want to locate prisons as institutions of governance. If life and liberty of the citizens cannot be deprived except according to procedure established by law, we should believe depriving liberty not necessarily lead to deprivation of life itself. Every year 2,000 prisoners are dying in India. Please remember that. If we want to preserve life of the prisoners, what are the conditions that will preserve the life which is not of that of an animal existence? Answer to this fundamental question will lead to answers that we are searching for. I think my own view is this is the broader framework within which I have been trying to search answers for bad conditions of prison. So I thought this framework putting forward is very, very important. But from the vast experience of being a judge, I think Justice Murlidharan will throw more light on this. Thank you.
Thank you, Professor Murali Karnam, Justice Mukta Gupta, Maya Darwala, Valay, Sashi Kumar, all the young students, Mr. Paneer Selvam, all the distinguished people in the audience. This is my first visit to Asian College of Journalism, and I should thank, I think, India Justice Report for that, because of the topic. I'm very, very happy to be here, to be able to share my thoughts with all of you. My first task is to see that post-lunch, some of you are still kept awake, so I'm going to say good afternoon and wait for the response. Good afternoon. Thank you. So we'll start at the very beginning, like Maria said in Sound of Music. So if we begin with statistics, and I think it's very important because many of you are students, some of you are law students. Any idea how many prisoners are there in this country? Any wild guess? You'll tell me exactly. Yes, please tell me exactly. Please stand up, please stand up. Yes, please. Perfect. Like they say in Tamil, Muru Madipengal. That is full marks, Mukta. Mukta is here. All right. So of this population of 5,73,220, which should be more by now, if you go by the previous trends, more than 75% are under trials. So I'll add to the popular misconceptions that Professor Karnam has been talking about. First misconception is that every prisoner is a criminal. So get that out of your head now. Okay. 75% don't know they are criminals. We don't know if those 75% are criminals. So it's a very, very important fact that you should acknowledge that till in our Indian criminal justice system, till a person is found guilty by a court of law, that person is presumed to be innocent. So then how do you call this 75%? And 75% works out to almost 4,34,302. So we have 4,34,302 persons in our prisons, which the system labels as under trials because they are expected to face trial. But as law persons, we are cautious and call them suspects. People suspected of having committed a crime. We even call convicts as persons convicted of a crime. So the language becomes very important. Otherwise, again, as Professor Karnam says, we'll end up having misconceptions and further confusions. We should not have conceptual confusions. As students, it's very important to be clear in our concepts. So we are talking of persons suspected of having committed a crime. These are what are called under trials. And they fill up 75% of the prison population. So if you enter a prison, the broad categorization is convicts. which as of today is 1,33,415. Under trials, which are 4,34,302. And detainees. They have a third category called detainees, and they are 4,324. Now, who are detainees? So, under our Indian Constitution, one of the sad parts of the Indian Constitution is one portion of a fundamental right which legitimizes or legalizes what is known as preventive detention. Preventive detention means under a law which preventively detains a person, again, suspected of having committed crimes, you need not produce such person before a court for a trial. This is an executive detention of a person for up to a period of 1 year, and in some states of 2 years, provided that that person is produced before an advisory board, which confirms or does not confirm the executive decision making regarding such detention. So, for instance, in Tamil Nadu, you have a Gundas, bootleggers, a long name it's got. You have an act which provides for this preventive detention. You have the National Security Act, which provides for detention. You have the COFEPOSA, the Conservation of Foreign Exchange and Prevention of Smugglers Act, which provides for preventive detention. You have the Public Safety Acts. Now, these are all progenies of a colonial law called the Defense of India Rule or Defense of India Regulations. So this is something that we've inherited, this system of preventively detaining. And if any of you, if some of you are in the first year of law, if you're minded to read the Constituent Assembly debates, this Article 22, the Article 22(4) of the Constitution came in for severe criticism because many in the Assembly were themselves persons who had been detained. Now this is a political device used by the British to shut away political dissenters. And it is continuing in independent India that you can use this device in a variety of ways to shut away people. So it came in for very, very severe criticism, but this is not the forum for going further on it. So you should understand that this 4,000 persons, 4,000 odd persons, 4,324 persons are detainees. They're supposed to have temporary stay in the prisons. So 3 broad categories: under trials who've not yet been convicted of a crime, convicts who've probably been convicted by one court and who probably are awaiting the result of their appeal, and detainees. So keep this broad classification in mind. Add to this a fact acknowledged by our police commissions. We have a police commission in this country, and you will have numerous reports on this. At least 60% of the arrests made by the police in the country are unnecessary. This is a fact that has been acknowledged and recorded not just by the police commissions, but the law commissions of India and other commissions which have dealt with the subject. So it is very likely that 60% of this 4,34,302 should not have been in the prison in the first place. So it's a very staggering figure that we're talking about, and why are we therefore, worried so much about prison reforms is, it is very possible that a large number of people in prisons ought not to have been there in the first place. So please try and understand the context in which we are talking of prisons and prison reforms. Among the people in this prison population are women, children, and foreigners. We have as many as 6,283 foreigners, of which more than 53% are from Bangladesh, 17% from Nepal, 8% from Myanmar, and nearly 6.4% from Nigeria, and 6.3% from Pakistan. So we have a large number of foreigners in prisons, apart from there being 1,312 women prisoners who are under trials, who are accompanied by 1,479 children. So under trial women are 1,312, and they have children aged up to 6 years staying with their mothers in prisons, which are 1,479, and we have 198, say approximately 200 women convicts accompanied by 230 children. So a prison population has a large number of people who probably should not have been there at all in the first place. Then there are people awaiting execution of a death sentence. So all over the country, this number has kept increasing. 190 prisoners were sentenced to capital punishment during 2022, and it's now taken the total number of those awaiting death sentence to 544. So that's the other category which you find in prisons. And prison, like any other collection of individuals, has its huge set of problems. And these are official statistics. The unofficial statistics could be much higher. There are 159 unnatural deaths of inmates. The total number of deaths is it is nearly 2,000, 1,995 in 2022. And they claim that only 159 of these 1,995 died due to unnatural causes. And these unnatural causes are suicide, which is a majority, murder by other inmates, which is 4, 10 dying in accidents, 1 due to outside elements, and 63 for which the cause is not known. Prisons and prisoners are economic centers, something that you don't wrap your heads around, which is not talked about often. Prisoners their labor is used to produce for this country goods worth over 267 crores. So people think prisoners are useless, they're dispensable, they're not contributing to the economy, are sadly mistaken. Prisoners contribute 267.03 crores to the Indian economy. In fact, Delhi High Court purchases the stationery produced by the Tihar prisoners. And many of us used to buy goods from the TJ outlets, Tihar jail outlets. So prisoners are usefully employed either in carpentry or in preparing food items. Apparently the Gujarati prison bhujia, or bhajia as they call it, is very popular. There are complaints before the National Human Rights Commission, State Human Rights Commission, but these two bodies, I'm going to say later also, are largely ineffectual in actually dealing with huge problems in prisons. Professor Vijay Raghavan talked to you about the overcrowding in prisons. The overcrowding in prisons in this country is over 100%, 130% is the extent of overcrowding in prisons, which means against a capacity. Any guess on how many prisons are there in this country? 1,330. 1,330 prisons in this country, which has a capacity of 4,36,266, whereas, as was pointed out, we have a population of 573,220, which is 131.4% over the prison population. So literally, there are some jails, and I know for a fact because of the 2.5 years I spent in Orissa, there are jails where the space is so cramped that prisoners have to sleep in turns. There are some prisoners who are standing while some prisoners sleep, and when they finish their sleeping hours, those standing are allowed to sleep. So it is that bad in Indian prisons. So one easy fixed solution is to transfer prisoners from overcrowded prisons to less crowded prisons, which is what they're doing at present. Because the increase in the number of prisons from year to year is barely minimal. There were 1319 prisons in 2021, and they could just add, the whole country could add just 11 more prisons in 1 year of 2021, so figure went to 1330. So that also shows what priority this is given in the overall scheme of things of the state. The age group of prisoners, largely more than 44% are in the age group of 18 to 30. And this is another very important statistic that you should be aware of, because this shows in their growing years, in the productive years, a large section of Indian population in prisons is actually being underutilized and wasted. The more we deny bail, the more we enact laws that make getting bail difficult, and the more arrests, pointless arrests we make, we're actually destroying the future of the younger generation of Indians, and this can have its own counterproductive effect. So this is an important statistic, that over 44% of the prison population is in the age group of 18 to 30, and the remaining 42% nearly of the remaining is in the age group of 30 to 50. So those who can productively use their lives are deprived of that opportunity, and for a variety of reasons, which I'm going to talk about. So what are the basic reasons for overcrowding? I know Professor Vijayaraghavan said that this has been discussed so much in the public domain, but I just want to recapitulate why there is overcrowding in prisons. One is there are increasing number of arrests. So the minute you have a muscular state, and the present dispensation believes it is a muscular state. We all believe, I remember growing up, my growing years, I don't know if Professor Karnam had this experience. I grew up in this city between the years of 1970 and 1985. So when the emergency was declared, many of the middle class families actually thought it was a good thing. They said, I went to the bank and everybody was in the seat, sir, at 9:30. Buses were coming on time, trains were running on time. They said, this is what we need in this country. We need a dictator. Even now you will find in the middle class homes, people actually saying, yes, we need one strong leader, we need a dictator. We have a fascination about dictators. A very funny incident, and I think you should know this, a close friend of ours has a friend from Germany who visits her very often. And after the third visit, he told her, you know, there's something curious happening in your country. She said, what? He said, I come to your immigration counter in the Delhi airport, and I pass through it. The man sees I have a German passport. So he turns to me and says, sir, Hitler is a great person. So this guy says, no, sir. In our country, Hitler is not a great person. In fact, it's a law against even saying Hitler is a great person. But sir, Hitler is a great person. Who? The immigration officer. So 3 times it's happened with him that Indians have appreciated who Adolf Hitler is. And there are some Indians who have also named their children after Hitler. So there is this fascination we have for the middle classes, because they have not suffered, till they suffer the excesses of a dictator. There is a fascination, which is why Hitler was so popular. I mean, after all, the Nazis ruled Germany for over 12 years. There is this fascination with dictators, with muscular governments, with strong laws. So brutal rape happens in Calcutta. What is the political response? Let's have a law that prescribes death penalty for rape. So as Professor Karnam was saying, and the earlier speakers were saying, it's a misconception. At least persons who are curious to know how the law works should not get excited that, there is a law now which prescribes death penalty. There's a popular misconception that if you have a strong law, there will be deterrence. People will commit those crimes less. History has proved this to be wrong time and again. We had some of the lowest conviction rates under the TADA, Terrorist and Disruptive Activities Act. We have very low rates under POTA, Prevention of Terrorism Act. You're going to have even lower rates of conviction under the Unlawful Activities Prevention Act, the present anti-terror legislation in this country. So time after time, history tells us that these so-called strong muscular laws do not achieve the above purpose of quickly bringing to trial the culprits and finding out whether they're guilty or innocent. They only reinforce the perception of a breakdown in the system of rule of law, where people keep languishing as under trials under these severe laws for several years without bail. What this effectively does is ensures that the process is the punishment. So in our heads, the collective thinking, we also have subscribed to this, that yes, it is okay if a person who is suspected of committing a crime under any of these legislations, it's okay if such a person is denied bail. The second perception is the police, why should unnecessarily police pick up a person? How many of you noticed in today's paper There's a news about Naxalites being killed, Maoists being killed in Chhattisgarh. Have any of you read it? So what did your first, because that's the headline, right? Maoists killed in Chhattisgarh. The newspaper has put it out. So did you all believe that those people who killed were in fact Maoists? You don't know, correct? When the Hyderabad encounter came out, the news, the 4 persons who were killed in an encounter, how many newspapers took the care to say 4 persons suspected of having committed a rape were in fact killed in an encounter? No. 4 rapists killed. So the media also lends to the public perception, and this is a college of journalism, so it's very important for us to emphasize this. The media adds to the perception that persons accused of crimes are themselves criminals, and that it's all signed, sealed, and delivered already, the verdict. So when discussion happens, whether it's in print or electronic media, or even social media, the discussion really veers around already presuming that the person we are talking about is a criminal, and how are we therefore treating this criminal, how are we reacting to this criminal. So if a court grants this person bail, they'll say rapist walks free. It's such a big misrepresentation. First of all, bail is only an interim, interlocutory in legal language, order, pending the outcome of the trial. Some person has already spent 3 years in jail. There's no prospect of the trial happening for the next 5 years. Or somebody has been convicted and he's been in prison for 7 years, 8 years. There is no prospect of his appeal or her appeal being taken up. Then the court has to take a call. How long do you keep the person in prison? Let's say the maximum sentence for a particular crime is only 10 years. The person has already spent 6 years. What happens if you take up the appeal after 11 years and you find that the person is actually innocent? You can't give back those lost years. So the court takes a call and says, okay, bail or suspension of sentence. But the projection in the media is as if the criminal has walked free. So there's a popular misconception, therefore, in media about what is happening in the courts, in trials, and this has also, therefore, induced a certain fear in the judiciary as a whole. So although you have Supreme Court time and again saying jail is the exception and bail is the rule, when it comes to courts on the ground, proximate to the scene of occurrence, I'm looking at a judge now in Calcutta, before whom this accused in the R.G. Kerr case is produced. What are the chances that even if the judge finds that the evidence doesn't quite square up, what are the chances that he will release that person on bail? Next to 0, right? So very often we feel that the local pressure, the societal pressure, the media pressure on the judiciary is so intense that every person who's even otherwise wrongly incarcerated, wrongly picked up, has to travel all the way up to the Supreme Court to establish the innocence at the first stage, to say that whatever material the police has gathered so far doesn't quite add up or doesn't quite point to my guilt. So that's exactly what is happening at the stage of grant of bail, where prima facie, the person has to show that he is not guilty of an offense. But these severe laws that we've enacted, whether it's the UAPA or Makoka that Justice Mukta Gupta spoke about, shifts the burden of proving the innocence even at this first stage on the person suspected of having committed a crime, when the person has no access to materials other than that gathered by the police. And materials gathered by the police are invariably that which will support the theory of the guilt of the person rather than prove the person's innocence. So I know I'm getting technical now, but the point that you need to bear in mind is it's extremely difficult in today's India for persons who are suspected of committing crimes under these statutes to try and establish their innocence at a stage when they have not yet faced trial. So we have an increase in prison population because of the enactment of laws that make granting of bail by the courts very, very difficult. When the courts do grant bail, and this is the point I think Professor Karnam and earlier Professor Vijayaraghavan was making, they impose such harsh conditions that it is impossible for a person to meet those conditions. A typical condition will be furnish a bail bond in the sum of, let's say, rupees 50,000, with two sureties of like amount. Now, for those in the audience who don't know what this legal jargon is all about, basically it's asking another person who knows this prisoner rather well to assure the court that if you release this prisoner now on bail, I will make sure that he meets the conditions of bail. One condition will be, every time the case is called out, the prisoner must be present in court. The prisoner will not intimidate witnesses. The prisoner will not do anything to frustrate the progress of the trial. Let's say these are three conditions. This third person, who knows the prisoner well, is giving an assurance to the court, yes, this prisoner will meet these conditions. When they say two sureties, which means two such persons have to say it. If the prisoner fails to turn up on a date and the case is fixed, the sureties will then have to cough up this amount, apart from the prisoner himself having to cough up that amount. So it's all translated in monetary terms. The prisoner undertakes the further risk of the bail being cancelled, which means the prisoner is back in jail. So this is what is meant as a condition for grant of bail, for release on bail, and many a poor person can simply not afford to meet these conditions. Let's say a person from Tamil Nadu who's caught in the New Delhi railway station and accused of having committed a crime, is lodged in Tihar jail and is granted bail. He has absolutely no one in Delhi who can stand surety for him, right? He has his roots in Tamil Nadu. He doesn't know anybody in Delhi. So if he can't meet these bail conditions, he's stuck there for God knows how long. There are less serious offenses punishable only up to 7 years, where even a condition of, let's say, furnishing a bail bond for 10,000 rupees or 20,000 rupees is impossible for a person to meet. And this brings me to the larger question of what we say the intersection of law and poverty. Many of the activities of the poor in the country are sought to be criminalized. For instance, begging on the streets, right? Some states have abolished it either through judicial verdicts or otherwise, but still in a large number of states in this country, seeking alms is an offense. So what do? You have the social welfare department every now and then conduct raids, bring these persons into the criminal justice system, produce them before a magistrate, and then the magistrate says you can be released provided you furnish bail bonds. The person is already seeking alms. There's no question of his furnishing bail bonds. Even in other not very serious offenses like carrying a knife, for instance, is punishable under the Arms Act. A cobbler can be arrested. That's part of his tools of trade. But he can be arrested because he does have a sharp object in his possession, which is answering the description of a knife under the Arms Act. So a large number of persons in our jail are persons accused of petty crimes because of their avocation or otherwise, like a sex worker. She can be arrested. She can be subjected to the same harsh conditions of bail, which she cannot afford. So many of these activities of the poor are sought to be criminalized, like sleeping on a pavement, encroaching, violating a municipal law. These are all offenses under those laws for which a person can be arrested. So if you're unable to furnish this bail bond or furnish this surety, you end up languishing in jail. Many of these offenses are what are called compoundable offenses, where you pay a heavy fine to the satisfaction of the court and your guilt will be recorded, but you can come out of jail. These persons can't afford even to pay a compounding fine. So time and again we have found that in this prison population of under trials that we are talking of are several persons, because of their economic vulnerability, cannot afford to exit the prison system. Then there is something called preventive arrests. A big leader is addressing a meeting tomorrow. Like all of you saw what happened to the Tibetan popular leader, Wangchuk, right? There was a 144 placed all over Delhi because they did not want Wangchuk to come and protest about what is happening in Ladakh. So they arrested Wangchuk at the border itself, right? They released him after a day, that's a different story. But there are many such what are called preventive arrests made. In the eve of elections, for instance, preventive arrests will be made. Let's say there is Moharram and Ganesh Chaturthi. Perfect combination for, a law and order situation. The police will step in and make what are called preventive arrests. But these can happen routinely. so the 107, 110 of the earlier CRPC, which continues in the new code, allows the executive, the government, to pick up people and detain them preventively for short periods of time. So those are also placed in the jail. And the continuing use of that is adding to the prison population. We also have types of crimes and profile of prisoners, adding to this prison population and making it extremely difficult for these prisoners to get out of jail. Let's say that there was a flooding in the basement of a coaching center in Delhi in Karol Bagh. This person was simply driving the car through that lane. He had no idea that the vehicle movement would cause ripples in the flooded water, which will add to the flooding of the basement. How is he supposed to even know this? He was booked for attempt to murder. I mean, because the media shrill cry of the media, because some innocent students, of course, died. But we lose our sense of proportionality. And when we lose that sense of proportionality, it induces a fear into not only the law enforcement agency, but even the courts. And coming out of jail makes it so difficult that it adds to the growing prison population. So broadly, therefore, we as a society still believe retribution as an answer. And we should remember that in our society, we have a very robust parallel system going, right? I have a fight with my neighbor in a village. I'm not going to go to the police first. I'll first go to the big person in that village. Literally, big person means person who commands influence. He could be a panchayat leader, he could be the sarpanch, he could be whatever. And if it is able to be resolved there, well and good. That person might make unreasonable kinds of orders. Doesn't matter, because I will stay in the village, I'll be part of that village community. So you have what are called khap panchayats. In Tamil Nadu, they are called katta panchayats, right? They pronounce all kinds of verdicts which to law-abiding people and people who believe in the values of the constitution will be simply unacceptable. But for that local population, they believe in it, they want to be part of that population, they don't want to face ostracism, they don't want to face boycott, they abide by it. Tribal communities, the way they treat certain members of their own community, some of it shocks our conscience. Like one punishment in a tribal community awarded to a woman who was guilty of living in adultery was gang rape. And a Supreme Court had to step in to stop that. What I'm therefore trying to say is there is a robust parallel system that we have to contend with. And there is a strong sense of retribution. Because today, if you had a referendum in this country, whether what West Bengal has done, prescribing death penalty for rape is right, it's quite likely that 85% of the Indian population agrees with that perception. Let's say castration is a punishment for rape. 90% of the Indian population will accept that as a valid punishment. So these are things that we have to ask ourselves, whether we want to subscribe to this kind of a rule of law, which hands down harsh punishments, because this gets into the collective psyche. When judges sit in courts, they're also part of this collective psyche. And to expect them to have a different mindset and to uphold the rule of law in the light of international human rights instruments is asking for a lot. Despite which, of course, we have a community of judges who believe in that, thankfully for all of us. And that's how we have a judgment like what came out on 3rd October 2024, and I'll talk to you about it a bit. So we also tend, like was mentioned here, to glorify encounter killings. You remember the garlands and sweets that were distributed to the police team that encountered those 4 persons accused of rape in Hyderabad. When the Bilkis Banu convicts came out of jail, they were all garlanded. There was remission granted to them. They came out of jail. They were convicts. They were not even under trials. They'd been convicted of the offense of gang rape, and they were felicitated by a whole community with garlands and aarti and whatnot. I think a minister also garlanded those convicts who came out on remission. So this glorifying that we do of encounters, of disappearances, you will find very little discussion on disappearances. At least 2 states in this country, Punjab and Kashmir, have had mass disappearances of persons. You still have some old narratives, if you if you are so minded to go into the net and search for it, about mass cremations in Punjab during years when Mr. KPS Gill was the Inspector General of Police there. Young youth were just picked up by plainclothes persons and actually taken, half-burnt bodies were then dumped into the 5 rivers that run through Punjab, whether it's the Sutlej or the Chenab or the Jhelum. So large number of bodies were therefore found floating, and only ashes could be recovered from the crematoriums where the burning happened of the bodies. No registering of crimes. Many years later, when I read the autobiography of Julio Ribeiro, have you heard of that name? Any of you heard of that name? It's got bullet for bullet. Ribeiro says how families used to bribe the police to actually book the persons picked up for an offense in Ratada. Because if you book a person, then you have to make a record of it. Then you have to produce that person before a court. The person doesn't disappear from the record. Whereas what was happening in Punjab is actually encountering or making a person compulsory disappear from records altogether. So we still don't know the truth of those events. There are many families who have no answers. World over, there's a movement of mothers of the disappeared, grandmothers of the disappeared. There are still those groups alive in Punjab and in Kashmir. It's only that young journalists or to-be journalists here should have their curiosity kindled by what I'm saying and try to follow up on those stories which have disappeared from collective memory of the public. So there is also a classist bias, the general perception that prisoners are having a good time. They have TV, they have AC, they have this, they have that. So when judges are taken on inspections, we have to announce that we are coming to Tihar. Immediately, like school inspections, I think all of you have been through that. Everything will be spick and span, right? All the best uniforms, even in the law colleges. When some guests are coming, all law students will be in the best attire, correct? Uniform. So same thing happens in prisons. So if you go to Tihar, they'll tell you about transcendental meditation, they'll tell you about Vipassana, they'll have some prisoners come up, stand up and say how their life has got transformed, how they're now repentant about what they did. So all the good stories come out. I'm not saying these stories don't happen, but these are not the only stories that happen, right? There are gangs operating in Tihar. There's sodomy practiced on young juvenile male prisoners. These are also part of the Tihar story. There's overcrowding in Tihar. There's great violence that happens in Tihar. Rajan Pillai, who was an industrialist, could not get timely medical aid. I happened to deal with that case, so I know it. And he died because of the delay in sending him in an ambulance to the nearest available hospital where he could get treatment. But there are many such instances in these jails. And jail violence is a real thing. So when you're presented a certain picture, like if you read I Dare, which is the autobiography of Kiran Bedi, she was the superintendent or inspector general of prisons in Tihar at one point in time, you will think that everything is hunky-dory in Tihar jail. It's projected as a model jail. But the fact of the matter, it's another overcrowded jail. So if you do surprise visits in jail, maybe you will get to know some part of the truth. But today, since 2015, visits by the media and filmmakers is completely banned and prohibited by a circular of the Home Ministry. So neither journalists nor filmmakers can enter the jails in our country. One of the early journalists, and her case is a reported decision of the Supreme Court in 1982, who made an attempt to interview 2 convicts on death row, was Prabha Dutt. Prabha Dutt, whose daughter is Barkha Dutt. Prabha Dutt approached the Supreme Court and said, I want to interview Ranga and Bila, 2 convicts on death row. And the Supreme Court permitted her. Of course, once she went, other newspapers also lined up and they were all permitted, but only for 1 hour, the court said. But that was the earliest attempt made by a journalist. Sheila Barse, as Professor Karnam was mentioning, visited the presidency jail in Calcutta, wrote a letter to the Chief Justice. She said, I'd gone to see the situation of women and children in jails in Calcutta. While one part of a letter pertained to women and children, and that was registered as a petition, another part was about persons labeled as lunatics who were found in the presidency jail in Calcutta. This had a whole story to itself. That was registered as a separate petition. Fortunately, I could be associated as a lawyer who had just become an advocate and record in the Supreme Court. I could be associated in that case. We could have a psychiatrist and a law professor visit every jail in West Bengal to find that there are a large number of persons kept in the jails in West Bengal on the ground that they are mentally unsound. Under the Indian Lunacy Act, if a person is mentally unsound, the person must be kept in a place of safe custody. There are not enough mental hospitals in the country, and the police in West Bengal understood the word safe custody to mean jail. So a large number of persons who were mentally unsound were kept in jails in West Bengal. That case and that report helped free many of them. Many of them had been abandoned by their families, which is a sad spectacle today, even in this country, that many a mentally ill person you find wandering on the streets, which by itself is a crime, under the Mental Health Act as well, lands up in jail. 1 year later, we found that that judgment was not implemented in Assam, so we had another round of litigation. So Sheila Bose, as a journalist, definitely contributed, like Sukanya Shanta now has, to the development of law and for a positive result for persons who are in jail who ought not have been there in the first place. So what are the major issues that we are facing today? One is that we do have judgments of the court, very progressive judgments, including the judgment that's been delivered just on 3rd October in Sukanya Shanta's case, which set out a large number of recommendations and which expect the state to respond positively to those recommendations. Before I begin with that, I want to show you a small clip of the real problem that we have, which we are unable to contend with, the overrepresentation of minorities in our prisons. When I say overrepresentation, an disproportionately large percentage of the jail population is of religious minorities, mainly Muslims, and scheduled castes. So I'm going to show you a small clip from this film called When They See Us. I should give you a small background. When They See Us is about the wrongful booking of 5 young black African Americans who were accused of committing a rape and murder of a white woman in the Central Park in New York. Many, many years later, after their incarceration of over 10 years, they could be freed. What happened to one of them when they were brought to the jail there is what I'm going to show you here. So what this clip shows us is that they use the convicts to what is called taming and under trial. And this is a practice regularly followed in Indian jails. Justice Chandru has written an autobiography in Tamil. It says Nanum Nidhibadi Anen, which is I also became a judge. And I've been persuading him to bring out the English translation of that very soon, and probably it will come by the end of the year, where he says as a student, he also went into jail and he received a similar treatment of being softened by the convicts of the jail. So there is a appellation given to the convicts of the jail. The persons attacking this person in prison, inside the cell, were the convicts of the jail, and the warder comes and actually encourages that. So they're called in India Munshi Kedis, who are actually helping in jail administration. There's a woeful shortage of staff in jails. So many of the tasks in the jails are performed by convicts in the jails, whether as cooks or security guards or within the prison, or doing menial jobs for the superintendent of jails and other assistant superintendents. So they're very much part of the jail administration, and they're formally acknowledged as such even in the new model prison law. So we use convicts to control under trials. I also want to show the kind of violence, therefore, that is condoned in the Indian jails. There's a wonderful film which flopped, by the way, at the box office when it was made, but I'm hoping that it will get re-released because it should be seen by a larger audience for the kind of message it puts out on Indian prison. This is a film called Ek Hasina Thi. So I'm going to show you a small clip from that, which shows what happens within the women's ward of a prison. So within a prison system, there are many favors to be sought and to be granted. So the currency is not cash, the currency is favors. And you have these narratives, if you're willing to read about them. One is a wonderful book called Shantaram by Gregory Roberts Davis, which is a kind of fictionalized account of an Australian who came and spent large years in Indian prisons, and he talks to you about the Baikula Arthur Road jail, which even today is an overcrowded prison in Bombay, and of the power dynamics within a prison. I don't know how many of you have seen the film Chicago. Have you seen the film Chicago? How many of you? Just lift your hands, I say. So wherever I would urge at least ACJ to screen this film, to understand how the criminal justice system worked in the United States in the early 20th century. We're talking of 1905, 1906. There are two aspects of this film which fascinated me. One, which is the concept of a cell block, where women prisoners were kept, who were accused of committing crimes. Many of them had killed either their partners, live-in partners, or their husbands. The early notion of what we call a slow burn, where you're consistently subjected to domestic violence and one day it all just erupts. But the clip I'm going to show you is about a lady, female warden, who goes by the name of Mama Morton. So this is a film that also shows you how the lawyers play such an important part. So when people ask me, why are all these reforms the court is proposing and the committees, law commissions are proposing, why do they work on the ground? So one important component of this entire system is the lawyer. And somehow the lawyer is not made part of the solution. In our country, the whole system of legal aid is not a lawyer-driven system, it's a judge-driven system. So the lawyers have no purchase, they have no stake in it. So lawyers still have a perception of doing charity through legal aid, saying, oh, I'll give up my paying briefs to do some briefs pro bono or at a lesser fee. So from their point of view, they're not going to get involved in an issue which carries it to its logical end. Having said that, I must say there is a small bunch of lawyers in this country, and Professor Karnam will bear me out, who are doing that extra mile, doing that extra bit to take up these difficult cases, whether it's in the beggars court or the juvenile justice boards or the magistrates court, who are putting themselves out there. But they are the ones looked down or resented by the larger lawyer body. So if you are a legal aid lawyer standing in court, the regular lawyers of the criminal bar will not let you function, or they will resent you very badly. So unless you somehow involve lawyers in this entire process of the jail visits or taking up cases of prisoners, you're not going to be able to find a lasting solution. Because like I said, this whole thing involves economics. There is something for everyone. I think today, just pre-lunch, Professor Karnam was asking me, people are not able to furnish sureties and they have to go to a lawyer for this. Can there not be a system where they don't have to go to the lawyer for furnishing surety? Many years ago, I had to get a will drawn up by my father's old friend, registered in Delhi. I, as a lawyer from the Supreme Court, went to the sub-registrar's office on Asaf Ali Road thrice. And every time the person there would look at the will and say, oh, this is wrong, that is wrong, you should have included this, you didn't put this stamp, something or the other. After 3 visits, I got so fed up. And I spoke to another colleague. He said, listen, why are you wasting your time? Don't you find there is a lawyer sitting outside that sub-registrar's office? I said, yeah. He said, go to him. Give him his fee, he will know what to do. So these are the barriers that ordinary people face. I mean, I faced as a lawyer. Ordinary non-lawyers would face even greater number of barriers. So this whole criminal justice system, when the court says release on bail subject to furnishing of bail bonds or surety bonds, that next step that comes of actually furnishing those bonds in the language of the court, in getting the sureties to sign bonds, to finding sureties, all of that is like a package deal, which the lawyer alone controls, and he's only able to find a solution for. So the way the system works, the lawyer becomes an integral part of it. So today he's a part of the problem. Unless he's made part of the solution, I don't think this will move forward. Just 2 or 3 small things before I come to another major chunk of my talk, which is on caste. We've used techniques, and there are devices available in the law to get people out of prisons. One is there are certain types of offenses for which you can release people on probation. But these provisions are seldom used. There are judgments of the Supreme Court reminding judges of the district judiciary that they should use these provisions. But like I said, since there is a collective fear, judges are reluctant to use those provisions. But that is a certain way of ensuring that the prison population is reduced. Then there are offenses for which the punishment can be either imprisonment or fine. One classic example is Section 500 IPC, of the earlier IPC, which is for criminal defamation. You all will recall how a Gujarat magistrate sentenced Rahul Gandhi to imprisonment for 3 years and a fine, although these were alternative sentences. And the High Court refused to suspend that sentence, and he had to come all the way to the Supreme Court, which reminded the court of the first instance that these were alternate sentences, and you need not have, ordered imprisonment for this kind of an offense. But this happened with Rahul Gandhi, who could afford to go all the way to the Supreme Court. But a large number of people who are not even aware of this possibility and who are therefore languishing in jail for compoundable offenses or fine being the alternative sentence are unnecessarily clogging up the jails. The third, I think I've already spoken to you about remissions. There are judgments now at the Supreme Court which say that we will commute the death sentence awarded, but we'll substitute it with a sentence of 40 years, 30 years without remission, which means the facility that you have after having completed 14 years to avail of the discretion of the government to be released at the end of 14 years after serving a life sentence, that is now taken away by the court by saying that you will be without remission for 30 years. That too is added to the prison population. And then, of course, the continuity that we lack, like the judgment that was just argued before Chief Justice Chandrachud, I had to tell the court that you cannot close the matter. Unfortunately, he's not done that. He's asked the case to be registered, saying in re discrimination in prisons, and the case is going to be listed after 3 months to ensure that the directions he's given in the judgment are implemented. So what was this judgment all about? This judgment of Sukanya Shanta versus Union of India, which was delivered on 3rd October. Shanta found in jails across the country, prisoners were being segregated according to their caste. In Tamil Nadu prisons particularly, the situation was very bad. When they approached the Madras High Court, and which is what is very surprising, when they approached the Madras High Court with a petition, the court glibly accepted that this is all part of reality, and if such segregation was not made, there would be clashes, communal clashes within jails, and so the High Court refused to interfere. And this is 2 prisons, one in Tirunelveli and another in Tuticorin. So this is also mentioned in the judgment of the Supreme Court. Can any of you tell me which film in the year 2021 brought out sharply the caste-based discrimination in prisons? All right, so that's good. Full marks to all of you. Can we have that clip, please? So what this judgment does has a long discussion on what are called habitual offenders. So many of these groups that you saw, Irulas and Koravars, they all were earlier during the British times notified criminal tribes, and then they had a law for denotification of criminal tribes. Although the law was for denotification, it continued identifying these people as habitual offenders. So the judgment notes how shockingly even the model prison law brought out by the Union government in 2016 and even the 2023 Correctional Act, Prisons and Corrections Act, continues describing what are called habitual offenders. And the entire system understands habitual offenders as persons belonging to the denotified criminal tribes, and therefore causes enormous harm to this one group of people. The judgment house shockingly notes there are many rules of prison manuals in the country today that provide for things of performing duties of a degrading or menial character, which can be performed if a class or community is accustomed to performing such duties. This is the prison manual of Uttar Pradesh. West Bengal prison manual, Rule 741 says, food shall be cooked and carried to the cells by prisoner cooks of suitable caste under the superintendence of a jail officer. Rule 793 provides the barber should belong to the A class. Sweepers should be chosen from the Mehtar or Hari caste, also from the Chandal or other castes, if by the custom of the district they perform similar work when free, or from any caste if the person volunteers to do the work. Rule 36 of the Madhya Pradesh Jail Manual, when latrine parade is being carried out, the Mehtars attached to each latrine shall be present. The Mehtars shall empty the small receptacles into larger iron drums and replace the receptacles after having cleaned them. Rule 563 of the Madhya Pradesh Manual says the cook shall be of non-habitual class. Rule 26.69 of Himachal Pradesh Manual says, if there are no female of suitable castes for conservancy work, paid sweepers shall be taken into the enclosure in charge of a warder and under conditions laid down in paragraph 214. Of course, the court says all of this is completely unacceptable under the constitutional scheme, where two provisions of the Constitution, Articles 17 and 23, actually describe untouchability and forced labor as constitutional offenses. These are the only two provisions which you will find in the Indian Constitution and not in any other constitution in the world, which actually describes an offense. Normally, penal laws will describe an offense, but Articles 17 and 23 of the Constitution of India say untouchability and forced labor, what is called begar. Both these are offenses and are therefore prohibited. So this judgment dwells on all these provisions to say they violate both these articles, 17 and 23, and of course violating 14 and 21. So that brings me to one last aspect about releasing prisoners on either parole or remission. There are a large number of prisoners who are awaiting release on remission. And for one mistake committed in one time in one's life, at one age, that person is made to suffer the consequences of that for the rest of the person's life. And the harshness of that is brought out graphically in this last clip I'm going to show you of a film which is a favorite of mine, again, which is a must-see for all of you as students, Shawshank Redemption. So the truth of the matter is, as was pointed out by both Professor Vijay Raghavan and Murali Karnam now, where they need help most is when they're in jail. They're cut off from the system completely. They don't know the fate of their cases. They don't know what rights they have. Even when they go before parole boards like this, there's no one to speak for them. And this is, I think, some area where collectively, by taking the bar in, and at this, I think we have to make the bar the solution, part of the solution. If we don't involve the lawyers, I don't think we'll find an easy solution. And we need to work on all these devices that are available in the law for people to exit from the rigors of a prison life. Lastly, I want to talk about the concept of open prisons. There are around 90 open prisons in the country. Open prison is a large, literally it's an open area, not like the walls of a prison. By the way, I don't know whether you're aware that this whole idea of panopticon was thought of by Jeremy Bentham, the legal philosopher. And he was the one, like the cellular jail in Andamans was on that model. Basically, it's like a watchtower that you have in the middle where you keep looking all around, right, to see which cell, what prisoner is doing, what kind of activity. So that basic panopticon model has continued through the ages. It's still a very harsh life inside a prison. Whatever people might say in popular medium that people have a cushy life in prison, it's far from true. If I were to just lock you up in one room in this building for just 5 hours, you will immediately sense a loss of liberty. So being in a place like a prison, sensing that loss of liberty can do all kinds of things to your mind. And I don't know how many people have read the books written by prisoners Do you know a famous prime minister of this country wrote a book that's a book for the ages about the history of this country sitting in a jail? Do you know which prime minister that was? And which jail was he sitting in? No. Naini, correct. Who said that? Thank you. Are you a student? I should have barred you from answering. It's very unfair. So, Discovery of India was written from the Naini jail by Pandit Jawaharlal Nehru. And have any of you read the book called Papillon? Papillon. No? This is about a person's, third, fourth attempt at escaping from a high security prison in an island which is controlled by France. You must read, these are all legendary, books that tell you, give you an inside perspective. In a person who's been inside the system and has come out, you get a good perspective of what is happening inside a jail. So open prisons is something that we need to experiment with. Another book which I would recommend to you is a book called A Reason Wounded by Primilla Lewis, who was a journalist herself. And yet another book is From Fancy Ward, which is one of the recent books by Sudha Bharadwaj. There are 3 books which are a must read. One is by Amir Khan, which reads Framed as a Terrorist. You'll find this all on Amazon. The second book is Beguna Qaidi, which has an English version as well, by Abdul Wahid Sheikh. He was falsely accused of being, of committing the Bombay blast, train blasts in Bombay in 2007, and he could come out only after almost 11 years in prison. The third book is 11 Saal. I'll just tell you the book. 11 Saal Salaankhon ke Piche. So this is by Mufti Abdul Qayyum Manzoori. He was falsely accused of being involved in the Akshardham attack. See, we are actually fortunate, I think as students, you're extremely fortunate that you have these personal narratives of persons who spent long years in prison. You'll get to understand what happens in Indian prisons if you read these narratives. And it's important to inform yourself of this. So open prisons, I would urge, is an experiment that should be continued and maybe expanded, and which can bring out the better side of people, make them into useful members of society, and be able to enjoy all their rights. I heard one question addressed to Justice Mukta Gupta is, whether it's even fair to talk about rights of prisoners when they've committed a crime. I hope you have some answer to that, because every prisoner is not a criminal in the first place, and even every convict. If you look at the Rajiv Gandhi assassination case, which was tried under the Terrorist and Disruptive Activities Act, 19 people were convicted by this judge in Punamali here in Tamil Nadu and awarded the death sentence, 19 of the 26 accused. When the appeal went to the Supreme Court, all of them, and I'm not making a mistake here, all of them got acquitted of the terrorist charges. And only 4 of them were convicted of murder charges. And you know what happened to the 4 of them? The death sentence was commuted to life by the Supreme Court, and then there was a long battle, even for Pere Arivalan here, to get them out on remission. But the point I'm saying is the margin of error is so huge. So even when you see the figure of 133,000 convicts, don't immediately imagine that all those convicts have been rightly convicted. The margin of error could still be huge. And like Akshardham, the trial court convicted them. They had to come to the Supreme Court to get the acquittal. And it's a long wait after 11 years and 12 years when we've lost the prime years of your life. But the more we write about it, the more we speak about it, that is the hope that we have to improve our criminal justice system. Aspiring journalists in this audience should draw inspiration from Sheila Barse and Shukanya Shanta. Do your bit, keep your eyes and ears open, keep writing about injustices. Someone will hear your voice somewhere, and we'll make all of this a better world. Thank you so much.
if we really believe personal liberty is the most cherished value, except depriving that, all other rights should be restored for the prisoners. This 5-star, low star, these are all useless talk. Prisoners are sent to prison as punishment, not for punishment. Please understand this conceptual distinction. Going to prison itself is a punishment. After going into prison, you are not supposed to be, punished by depriving your decent working conditions, giving food. So that is fundamental. If you understand this, you will not have any doubts about whether prisoners should be given rights or not, except to personal liberty, because we all believe personal liberty is the highest value of this civilization. If we believe that, all other rights should be restored. That's what Supreme Court said. Let's stay with that. The second small point I want to say is, when Sukanya Santa was doing her dissertation with me, I was her teacher in TIS. She went to a journalist and asked, when there was a theft in small town, she asked a journalist, why did you write is a Parthi? Parthi community is a denotified community. The journalist said, no, that is the practice here, we will do it. So you can understand the role of journalists. So the domain of prison is as complex as any other things. The minimum thing we can do as journalists is not to perpetuate the existing system. If we want to contribute for that, I think we need to develop a systematic understanding like tax and death, law is also permanent. If you want to write about law as a journalist, you should develop a little bit of depth of understanding, otherwise you will be perpetuating the injustice that is going on. With that, I will invite questions from the audience.
Good afternoon, sir. My name is Vaishnavi, and I'm from the Asian College of Journalism. My question is to Justice Murlidhar, sir. In your speech, you had given us some staggering numbers in the initial part of the speech, where you had mentioned that there's been unnatural death of inmates, and a lot of people who aren't meant to be in the prison are in the prison in the first place. So basically all of this, and you had also shown us clips, on how there's a lot of toxic environment within the jails itself, and how these people, the innocent people, suffer a lot mentally. They're tormented to a lot of torture. So my question to you is, what is the system doing to provide mental well-being to the inmates, because that is very, very important, necessary, given that even in the recent few weeks, the case of Anne Sebastian, and they talk about toxic work culture and how it's, putting a lot of pressure on the mental well-being of people. What is the justice system doing to promote mental well-being among inmates? And how, after these people, the innocent ones, they have, wasted their years in the prison. So once they are let out, it is still, affected their psyche to a great extent. So after they are being released, are they even provided, aid in terms of mental well-being? That's my question.
Yeah, on the first part, it's only in Orissa, as far as my memory goes, that when we were dealing with the PIL concerning prisons in Orissa, that we had in fact, it's there on the website of the Orissa High Court. We have what is called a PIL portal. If you go into the PIL portal, you will see the video clips of the live streaming of the prison reform hearing. And you'll find that we had Maya Daruvala, Professor Karnam, Professor Vijayaraghavan, all participate in the hearing in the court. So we could bring about a lot of attention to these areas. And one area there was the mental health of prisoners. So because of the court's intervention, we could get a large number of psychologists and psychiatrists come on contractual basis to visit the prisons in Orissa. Otherwise, those posts were all lying vacant. And although they have in other states also these posts, rarely do they get filled up. but it's also mirroring what's happening in the country otherwise. I think India is the country with it's a very skewed psychiatrist, mental health population ratio. Very few competent psychiatrists, and among them, again, very few who visit jails. And this is an area we have to pay attention to. It's calling for an urgent attention. So that's one way of bringing it. In every high court, there is some PIL or the other going on. And I would urge people to intervene in those PILs and to ask for the survey to be conducted about how many prisoners require counseling. And the point you make about after-release counseling is also absolutely essential. It's a neglected area. I don't think we're paying attention at all to it.
Yeah. Actually, after COVID, Supreme Court asked a study from NIMHANS. NIMHANS study says for every 300 prisoners, there must be one psychiatrist, but we have one psychiatrist for 10,000 prison population. And 90% of psychiatrists produced by this country are going to America, period.
Yeah, thank you, Justice Murlidhar, for that fascinating overview, kind of toward the horizon, if you like. Just one part of it, a small part, you made a passing reference to it, about how judges are influenced by the mood of the times or what is dominant. And their media obviously plays a big role. The times also play a big role. We are living in times where a kind of lynch mentality is being normalized. How much of this does affect the perception of judges? In a context where we are told, at least clinically, that all judgments would be evidence-based and so on. I ask this because one phrase which occurs in judgments, particularly where harsh punishments like capital punishment and so on are, something which goes, unless we hand out this sentence, the collective conscience of society will not be fulfilled. That almost sounds like baying for blood, I mean, if I might put it crudely. Why and how can't justice be more insulated in that sense?
Yeah, it's a valid question. Actually, very early on in South Africa, this is a fascinating history of South Africa. You know, when they made that constitution, they came up with this Truth and Reconciliation Commission. And they anticipated that there'll be people baying for blood because of the deep scars of racial laws in South Africa and segregation and all of that. And so those wise persons who framed the constitution thought we should have it as part of the constitutional framework. So one of the early challenges in South Africa was to the constitutional validity of death penalty. And they struck down the provisions on death penalty. One of the judges, Arthur Chaskalson, has in a nice passage, which I very often use, says that, if you held a referendum in South Africa, and he was talking in 1996 or 97, he said, if you have a referendum today in this country, 90% would want the death penalty. But what are we here as constitutional courts? We're not here to, just reflect whatever the majority wants. We have to uphold the constitutional values. That's what we are here as a constitutional court. Otherwise, all these issues can be decided by a referendum. Why have a court at all? So we use this passage quite often, and even our Indian Supreme Court, we've made this rarest of rare test, because we know world over there is a trend of moving away from death penalty. But unfortunately, in some countries in the world, we are regressing. And I'm afraid we are regressing here. For the smallest kind of opportunity that we have, the political window that we say, we seem to think that people will kind of feel satisfied if there's an announcement made that this crime will have death penalty as the punishment. So that has weighed with the judges, and there are definitely those smaller number of judges who believe that the judiciary performs what is called a counter-majoritarian role. Not an anti-majoritarian, but a counter-majoritarian. To say, listen, there is this other way of looking at things, and like this judgment in Sukanya Shanta, I would think is counter-majoritarian. It's made a very, very important contribution to Indian jurisprudence in helping people think outside of this caste framework that is so deeply entrenched in our system, particularly cleaning of toilets, whether it's in school buildings or other places, public places and prisons. We call upon certain castes to do that degrading work. And we don't even question it. We accept it as a given. And so I think this is a very valid question, and it can only happen through judicial academies, more and more sensitization, and more dialogue on this.
Hello, sir. I'm Apurva. I'm a student at ACJ. Thank you for that talk. I thoroughly enjoyed it. My question to you is, so you mentioned that 70% of the people in jail are suspects. You also mentioned that the media plays a role in criminalizing these suspects, and also that journalists or filmmakers are not allowed inside these jails. We can see through media and through especially social media that criminals are largely considered to be monsters. In fact, everybody inside a jail is considered to be monsters. And when journalists or filmmakers are not allowed inside jails, it helps further, it creates a ripple effect, right? What do you think law and order, especially courts, can do to ensure that such a thing does not happen?
Look, greater transparency. Actually, when you have these hearings on prison reforms at greater frequency, you will have a greater participation by the public. We need to have the dialogue, because it's not happening in Parliament, where it should happen. It's otherwise happening in closed spaces like this. I think use court as a democratic space and bring some of these issues to the court and hope that the court has time to look at them. It's just a hope that we have. But we need to keep placing it in public domain, these issues. Fortunately, today you have a social media. You can even have a blog post, which somebody can then pick up. So use the social media as effectively as you can. And even released persons who are released from jail, can tell you so many things about the jail. So somebody comes out on bail, you can assure them of protecting their identity, but get them to speak to you to see what is happening inside a jail. You have protection money being given, not just to the warders, but to the convicts in jails, so that your family member doesn't get beaten up. So these kinds of things need to be talked about more often. Yes.
Hello, sir. I'm Lahero from ACJ, Asian College of Journalism. I have two simple questions. In the pre-lunch sessions, we talk about how media behave and how media label people arrested as criminals, or how media convict them even before they have been produced before the courts. So I want to know whether there is any judgment or any person has challenged the behavior of media in this country. And one question.
Yes. In the Sahara, this goes by the Sahara case. This was an offshoot of the Sahara case, where there was a lot of news put out about what was happening in the Sahara case. So they had an offshoot of the entire judgment. It's almost a 200-page judgment on trials by media, and wanting guidelines to see what media can and cannot and should not do. So it's a very detailed judgment. Again, there are many judgments now, but what the person who said, I've read so much about the evils of drinking that I've stopped reading. So it's almost like that. We have so many judgments on prison reforms. I hope people don't stop reading those judgments.
Okay, so one more question. So we talk about habitual offenders, but based on caste or how they are labeled like this. But my question, I want to know, what is the percentage of people or the prisoners returning to the prisons more than once based on the same crime?
Less than 5%.
The term used for that is recidivism. Recidivism is the term, the phenomenon that you talked about. The person committing the crime again and returning. Yes.
Next. Before we move on, one small clarification. See, this 5,75,000 prisoners is per day average, but it is per year. 18 lakh people
Coming in and going out, yeah.
18 lakh people go to prison and come out of the prison. On any day, in America, there are 2.2 million people. My fear is in 10 years, we are going to reach there, unless we seriously try to do something. Please.
Thank you so much, Professor Murali Karnam and Justice Murlidhar. I am Ananta Kumar Giri from the Madras Institute of Development Studies. Justice Murlidhar, you presented so many important aspects of our life world, including the practices like sodomy in jail. And it reminds me of Gandhi. When Gandhi was in prison in South Africa, the night he spent in prayer is that he should not be subjected to sodomy. My question is, what happens to these kind of practices, in the jail, or how does the court take note of it, including jail violence? Secondly, in terms of open prison, you seem to be for it. Could you please describe for us what kind of practices go on? And like your reference to the South African Truth and Reconciliation Commission, some countries in the world, for example, Norway, has a very interesting kind of prison space. So as we are talking about global learning, what kind of transnational learning? So far the discussion, your reference to the American films are very important. So what kind of transnational learning we need to do? And my third query is that you referred to the limitations of the judiciary. One important notice we see is the politicization of judges. And quote unquote, there are many judges now who have a very spoken or unspoken political color. What do we do about it? And many of the arrests are done because of this kind of the politically motivated judges.
I try to answer one or two. The first question is about sodomy. Indian Supreme Court has struck down 377, but still bestiality is a crime. In Indian prisons, all people who resort to consensual sex are all branded as mentally ill prisoners. So when I go to prison very frequently with my students, so they are considered as mentally ill. That is the status that has not changed. Okay, that's one thing. So outside there may be a lot of movement about LGBT and everything, but prison things have not changed. The second thing is about open prisons. Out of 90 prisons, except in Rajasthan, in the entire country, they are not open prisons at all. There are more prisons, they are not open. There is gate, that doesn't mean that it's completely open, but only in Rajasthan and a little bit in Madhya Pradesh. In open prisons, there are no barracks. Prisoners can live with their families, go out to the city, 25 kilometers. They can run their auto rickshaws and do some job, but before 7 o'clock, they have to come back and give attendance. This is much more effective, but you are eligible to go to open prison at the fag end of your sentence. After 10 years of being in the closed prison, on the basis of good behavior, after excluding all those people who have committed so-called grave crimes, offenses against women are not allowed to go to open prison. Those who committed offenses against SC/ST or attack on public servant, NDPS and TADA, whatever draconian laws, they are not eligible. So therefore, open prisons are accommodating only 5% of its capacity. 95% of the open prisons capacity are still vacant, because the fundamental principle, like our new laws, gravity of the crime is the only criteria around which entire prison reformation is designed. Whether inside the barrack you should be allowed for 5 minutes, whether you are given more facilities to talk to your family members, whether you are employed as a prison laborer, for everything gravity of the crime, which means consequently like in that Shashank Redemption, that clip, 20 years back you have committed a crime, that will continue to govern the government's behavior towards that prisoner, which means there is nothing like a reformation. The attitude of a policeman continues to govern the attitude of the prison officers, attitude of the judges. It is the attitude of the constable which is governing the entire process of arresting, releasing, everything. The third question, I don't know how to answer. I think probably Justice Murlidhar can answer that.
Yeah. Actually, the third question is not problematic for me if I look at history. I think all of you should again see a film called Judgment at Nuremberg. Okay. What is fascinating about that film is the judges who operated during the Nazi era believed that they were upholding the rule of law. And one of the earliest things that the Nazi regime did was to change the constitution and change the laws. And therefore, judges were enforcing, not just upholding, but enforcing the laws that segregated Jews from civil society and discriminated against the Jews. So many of the judges who were put on trial, that film is fascinating because all those judges were put on trial at Nuremberg. And many of the judges in their defense said, we had taken a constitutional oath to uphold the rule of law, and we were precisely doing that. So judiciary being used by a dominant majority to achieve its ends is nothing new in history. It's nothing new in history. Exceptions are when judges stand up and say, we'll refuse to be co-opted in this political agenda. A majority of judges are likely to be co-opted. If you read the autobiography of a former Chief Justice of Pakistan, when Zia-ul-Haq came to power, and when Musharraf again came to power, judges were asked to take an oath, a fresh oath. So Pakistan has seen through all of that. And there are judges who resigned, saying, we won't subscribe to this. So there are numerous examples in history where judges come with clear political inclinations. They may not be public about it when they should be, but we have had those instances, and now we are seeing more of it because a certain dispensationist power, they feel, okay to come out with their political preferences. But we are looking for those judges who will not succumb to this kind of a political agenda and stand up for constitutional values and stand up where it counts. So history tells us about those judges as well. Like H.R. Khanna. We do celebrate H.R. Khanna's stand in the ADM Jabalpur judgment. So you will find such instances of judges standing up where it matters.
Hello, my name is Amashay Khalid. I'm a student from ACJ. My question is to you, Murlidhar sir. Sir, so the budget of 2024 has allocated about 2,19,000 crore to the Ministry of Home Affairs. But from the data that I've seen, about 1,50,000 has been allocated to the police and salaries of lawyers. After looking at data for 4 years, I've also seen a trend where most of the money has been allocated to the police forces and lawyers. So, sir, if the finances are not going in the right place, how can state governments focus on, prison reforms when they're not able to finance movements or as we said, mental health ideas and everything when the finances are not right? So my question is, should this be a larger debate to be talked about in the budget? And if so, how can we curb this issues of overcrowding that is happening if the state governments are not getting the budget, right?
So you've done the first right move, right? You've studied the budget figures. So this is the first move. It's a see, if you see the prison statistics, we have the latest prison statistics which is brought about to the National Crime Records Bureau, NCRB. The last we have is of 2022, which is available in public domain. That tells you what is the percentage of the overall budget which is allocated for prisons. But the second line in that statistic is important, that only 80% of that amount is spent and 20% remains unspent, right? So this is the story across governments, and I know of the judiciary as well. We are unable to spend the money that has been allocated for a variety of reasons. That will take another whole 1 hour. But just go deeper into it, right? Even when you suggest that there should be a greater allocation, you should be able to suggest how to spend that allocation efficiently. Otherwise, you're going to give it in the hands of people who don't know how to spend it or who are reluctant to spend it. Then you will open up this whole other debate of public-private partnership, even in the running of prisons, privatization of prisons. By the way, privatization is already happening. Like Tihar jail, there are 2 corporates that are helping train the prisoners in producing those goods I was talking about. Karnataka, Gujarat, those prison authorities have tied up with corporates to train their prison population in producing goods. So there's already a debate happening in that direction as well. So maybe you should look at it from a holistic point and don't pick up only this figures of budget allocation, but go deeper into it. That's what I would suggest.